requires you to do. So they highlight that obligation, making sure that any product specified has that evidence. On-site inspections, there's a whole section on that, and that aligns to what we've just been talking about with the ultimate construction of your designs, and expert witness obligations, including in there, I guess confirming what you all should know, that you're not hired guns. You're there to assist the courts and tribunals, and also highlighting the obligation where you change if you've delivered a report and it's been filed and you change your mind for some reason, some new information, that you must proactively produce a supplementary report and make sure it gets filed. You don't wait for instructions to do that. You must proactively do it. It's your responsibility. And that, I'd like to think, comes from the House with No Peers case, but I'm sure it's broader than that. Yes?
Does the standard apply to, say, Victorian engineer working on a New South Wales project?
How does it work?
The question was, does the standard apply to a Victorian engineer working on a New South Wales project? I guess it depends the capacity in which you're working. So there is, of course, as there is in all these registration schemes, the ability to have to be supervised. You don't need to be registered if you're being supervised, but if your name's on it, then I would have thought if you're doing work in New South Wales on New South Wales projects, you ought to be registered up there, and this will apply to you. But if you're just working under supervision or part of a team where someone else is the engineer that's appointed and they are in New South Wales already, then you wouldn't need to be. But they would, so they're going to expect you as part of that team to be helping them meet their obligations. So I think it'll get you one way or the other. Make sense? My dinner's still not here, so I'm going to keep going.
What did you order?
I ordered the gnocchi. I might have been the only one, am I? Anyway, keep going.
I'm still waiting.
You're still waiting too? Good. Okay, broken promises, blame games and balconies. I'm having fun making up the names of these reports, and you'll see why we picked those three descriptors. Yes?
The practice standard, where can you find it?
Just Google it, New South Wales Engineer Practice Standard, you'll get it. Yep. Okay, so this is a case study a second case study that David Chamblick has commissioned me to do, and this one's on the Otto development, which is a multi-storey residential development in New South Wales, two separate owners corporations, but this case study is just about Otto 2, 143 sole occupancy units, four different towers with a shared podium and basement. So 3, 6 and 7-storey towers in the Otto 2 Owners Corporation, constructed between the end of 2013 and the middle of 2015. The owner of the site was Sydney Christian Life Centre, otherwise known as the Hillsong Church, and you'll see why that's relevant later. The developer was a group called Capital Corporation, but they created a special purpose vehicle for this project, and I call them the developer. They didn't actually own the land, so they were engaged by Hillsong, who had some land that they purchased from the New South Wales government, and they wanted to put a church and parkland on that land. But when they went through the planning process, they got a lot of pushback from local communities who did not want that being built. And so they decided, well, we may as well do some development on it and sell it and make some money. And so along comes Capital Corporation, which does a lot of these sorts of developments for religious or sporting clubs or other groups that have land that they want to do development on, but they don't have the skills for it. So they often act in these arrangements. They created a special purpose vehicle that was the developer for the site, but it was through this joint venture with Hillsong that they developed the land. The builder was Icon Constructions. Does that name sound familiar?
Yes.
So it was one of the entities, Icon Constructions, that constructed, of course, the Opal Tower. which we'll all never forget. This particular entity was established in 2012, and the project was $41 million for the Otto 2 part of the development, and the certifier was a guy called Peter Ancliffe. And the reason why I'm sort of going through who everyone was because separately, the House of No Peers report that we didn't have any names of anybody in it. In this one, everyone was named. And that was, from the beginning, that was the intention for the report, that everyone would be named, including names of directors and law firms that were involved, all that sort of stuff. So the certifier was a guy called Peter Ancliffe. He did around 10 inspections on the project, which was pretty typical back around that time, 2014, 2015, about how many inspections you would do on an apartment complex this size. Next slide. The builder was sold, this Icon entity was sold in April 2015, which was just a couple of months before the property received its occupancy certificate. So from that time in April, it was not receiving any income. And the arrangement that was in place was that the related entities were providing services to the Icon entity to help it finish off its projects, but the Icon entity was no longer entering into contracts and no longer actually doing any work itself. There was, as happens reasonably regularly in New South Wales, a strata company appointed by the developer, which the owners then changed 1 year out and alleged that the strata company was not responsive to it in relation to defects that were starting to emerge quite early on after occupation certificates were issued. The lawyers for the Owners Corporation were a mob called Chambers Russell, one of the very well-known OC firms in New South Wales that does a lot of work in this space. Legal proceedings commenced in mid-2017, which you'll notice is almost 2 years from the OC being issued, and that's because in New South Wales you've got 2 years to bring proceedings on anything that's not a major defect. And so there is this business model that's grown up in New South Wales where at the first AGM of the Owners Corporation, people start talking about getting lawyers in and defect consultants because they don't want to lose their 2-year window. So they actually bring people in to start looking for defects, which has created a very strong litigation culture in New South Wales. In fact, when I spoke to the director of Icon, he said, look, we do work in Queensland, Victoria, New South Wales. Our work is the same, whichever jurisdiction we're in, but everyone ends up in court in New South Wales. Doesn't matter how good you are because the litigation culture there is so strong. My view is that it's because of this 2-year limitation period, has everyone running around looking for problems because they don't want to miss out on bringing their claim. So, of course, yes, just on the 2-year limitation period, and they have lawyers come along to these Owners Corporation meetings very early that are referred in by the strata managers to start telling everybody we've got to make sure that we find defects so that we can get you in front of the courts quick, smart, and there's a whole business model around it up in New South Wales. 6 defect reports were done, not necessarily before they issued proceedings, but over the period. And there was this one engineer called Mr. Braun that did a report. Now, he came to the site to look at some issues around cracking and other engineering issues. And he was looking at a particular part of the concrete construction, and he was out on a balcony looking, and he leaned up against the balustrade and he was like, "Ooh, that's not very sturdy," which caused him then to look more closely at the balustrades. And in his report, he said these balustrades have not been constructed in accordance with the standard. They don't have the strength that they're required to have. These were glass balustrades. Every one of the 143 apartments had one of these balustrades. Next. I don't think I'm eating tonight. Oh, you are? Oh, look, it's all right. I'll just keep going. So the OC, there's then a bit of media interest for a couple of reasons. One is because it became apparent that the Owners Corporation started to restrict access to balconies, started writing to lot owners saying, you better not use your balcony, we've got this report, they're not safe. And somebody then reported that to the relevant local council, and they got a bit nervous about it. So they issued orders on the property restricting everybody from accessing their balconies. And somebody from the media got wind of that as well. We don't still know who told the media about it. But because of the relationship to Opal Towers and to Hillsong, this was a really interesting media story. And so that's what caused a bit of media attention.
On its way.
And around about this time, the Office of the Building Commissioner was being established, and one of the, obviously the projects that was put onto David's radar very early was Opal Towers. So he was engaging with Icon about Opal and what they were doing there, but also about these other projects that were involved with the Icon group. And he was being told and getting updates from the Icon group regularly that they were going to be resolving all the defects in their properties, including rectifying the balustrades at the Otto 2 project. It took until 2020 before a balustrade rectification plan was produced by Icon, and according to the director of Icon, he said the OC lawyers were impossible to deal with. And causing a whole lot of problems. When David Chandler was saying, why is this taking so long? He said, look, these OC lawyers are just dreadful. They won't let us on site. They won't agree to anything. So David reached out to the OC lawyers and said, hey, what's going on? Can we help here? Would you like us to get involved? And they said, oh, look, no thanks, Mr. Commissioner. We're all good. Nothing, no problem here. This isn't our fault. We don't need any assistance. The OC engaged an expert called Radcliffe, who's a water expert. So some of the issues, in addition to the balustrade safety issues, there was waterproofing issues on the balconies, which obviously another very common defect that we find. And so he was looking into some of those. He also looked at this rectification plan for the balustrades, which one of the big issues was whether or not the whole of the tiling needed to be pulled up in order to replace the balustrades, and then how that might affect the waterproofing on each balcony, and what was the proposal for rectification. I'm sure there are people in the room who know a lot more about this stuff than I do. He actually said he thought the proposal was reasonable and that they should move ahead and start to rectify these balustrades using this plan. The OC's lawyers didn't like that, so they replaced him with another expert. November 2020, Icon goes into administration. And this is a great shock to the owners and everybody's. They've already spent a fortune on lawyers by this time, of course, and this was one of the things that the Icon director was saying to David, look, we cannot move forward. We've spent a fortune on lawyers. The OC's lawyers are just impossible to deal with. This is going to cause us to go under. And of course, that's what happened. They said that they'd spent about $1 million on legal and consultant fees by that time, and the whole thing was irreconcilable. Next slide. The insolvency documents said that there were $34 million worth of creditors for the Icon company, and that around about $10 million of that was attributable to the defect claim for the Otto 2 building. About $1.1 million worth of those creditors were related entities and trustees and in the names of the directors, and the related Icon entities were also owed quite a bit of money. But notwithstanding the fact that the entity responsible had gone into administration, spokespeople from the related entities said, and even said in the media, we will continue to work with the stakeholders, we won't walk away. Hence the broken promises bit of the title for the report. They kept giving assurances to David Chandler that they were going to honour these issues until they were issued with a rectification order, and they very quickly took the New South Wales government to court and said, we're not the entity. So the government sort of went to go against the related entity, and they said, we're not responsible, we're not taking responsibility anymore, we've got no legal obligation in relation to these defects. The lights were off, nothing was going to happen. So the RAB Act came in January 2021, and David thought this is a great opportunity for me to see how I can use these powers for an existing building. So he wanted to get involved in this project, and he issued a rectification order to Capital in the May after they'd been in themselves and done their own investigation of the alleged defects. And by August, Capital had negotiated a payout with the Owners Corporation. Now, whilst I know what that figure is, it was confidential. I'm here. And so I can't tell you what it was, but it was for several $1 million. And now I'm going to have dinner, and then I'll come back and tell you the end of the story.